Alex here with part 25 of the My Docket series on child custody and visitation. As with my previous videos, I'll direct my viewers to part 0 if you haven't seen it yet. That is the video that contains the detailed disclaimers and the underlying purpose of this channel. Actually, of this series specifically. Two things that I will glaze over are, number one, I'm not in the middle of this right now. My case is completely and totally closed. It can't be reopened, and that's because my ex's parental rights have been terminated. Number two, the nutshell version of the purpose of the series is to give my viewers a big example of my 8-year-long high conflict child custody ordeal from beginning to end in chronological order. We left off in the past, let's say 6 videos with the motions, oppositions, and replies filed with regards to my efforts to have my ex held in contempt of court, have the temporary custody orders and child support modified, and there was a little spat in there where my ex's attorney tried to strike my request for submission. And this video we go into our first of at least 2 orders, possibly 3, but I think it's just 2. And this is an order on my efforts to have my ex held in contempt of court. Typically, before I get into the analysis on the document, in this particular case it's a court order, I like to sort of share what my mindset was between the last video and this video. There was not a whole lot of time that elapsed, but I can remember 2 things distinctly. One thing was the fact that I felt empowered by the ability to force a decision. Not necessarily a decision that I was going to win. Of course I would have liked that. But I didn't know that a person could file a document and get a formal legal response from a judge. I didn't know it was that simple. And it's hard to say that simple, but when you're thinking in terms of impossibility versus having to do a lot of research, learn, and do a lot of work, it does make it seem simple when you compare all that effort to your prior perspective of just this isn't even a thing you can do no matter how hard you try, no matter how much you want to. I don't know if it was so much that I assumed you had to be an attorney to do something like this, or if I just thought, or if I just wasn't thinking at all about it. And when the realization dawned on me that I could file a motion and get a response from a court, it was a lot of what sort of drove me to really come to the realization that I didn't need a whole lot of money to fight for what was best for my son. I could do it on my own, despite how hard it would be. There was a path to victory, and that was one of the things that I was beginning to realize. I recall that feeling distinctly, and the other thing that I recall is the just horrible knot in your throat that you get when you finally get that order. At the time it would come in an envelope. I wasn't, non-attorneys couldn't use the electronic filing system back in 2008 or 2009, and so an order would come in the mail and it would have the judge's department on it, and it was obvious what was inside of that document. And so I will never forget that, and it's still to this day has not gone away. Even now, after all these years, when I get a court order and I haven't read it yet, that just, you get this knot in your throat. And I think it's just because you've invested so much work and time and emotion into it. And it's like the exact opposite of ripping off the Band-Aid really quickly. It's ripping it off really torturously, slowly, over the course of who knows how long you've been waiting for that order. Oftentimes I would be waiting 2 months. And so when you finally, I don't think it would be as bad if you filed your motion and you got a response from the judge within 10 minutes. It's just when you're waiting and you're thinking about it on your way to work, on your way back from work, while you're at work, when you're trying to go to sleep, and sometimes you can't even sleep because you're so anxious waiting for some kind of response from the court. So that is one of the things that I wanted to bring up in this video, is that strong recollection of that almost debilitating sense of anxiety at having a court's order in your hand yet not having read it yet. And when it comes to an order that's going to impact your relationship with your children, I'm not sure that there are many things that can really trump that, something like that. That's kind of at the top of the list for any human being that, you know, has children. Their children are just, they mean the world to you. So I suppose at this point I can go ahead and go into what my judge has found. Here we have the judge's entry of an order denying my motion to have my ex held in contempt of court. For anyone who is curious, the motion itself I discuss in part 17 of the My Docket series. It's a must watch because this video is just going to analyze the court's order, and I think it's really important for people to understand my thinking at the time that I filed the motion, and also my perspective on whether or not I even should have filed it using the experience that I have now 10 years later. And I even go into technical details such as the appealability of the order to show cause, if it's issued or whether it's not issued, and my approach to filing certain papers that are difficult to challenge on appeal, because I have sort of a different approach to filing things that are difficult to take over that judge's head, where as opposed to filing something that I can take over that judge's head more reliably, more predictably get some kind of order, having that judge's decision overturned. In this case, contempt motions are very difficult to challenge, and I talk about how I approach them differently using the experience I have now than I did at the time when I filed something like this. And of course, I indicated in that motion in part 17 that it would ultimately be denied, and I also indicate that I'm not really too surprised given what I know now that it was denied. So part 17, if anyone is curious about that, I'm going to go ahead and get onto this order. First paragraph, the court goes over the briefs. In this case, the briefs are the motion, the opposition, and the reply. The court also mentions the specific dates that those documents were filed, which is important because in these cases, sometimes multiple documents will be filed with the same title, and the court will sometimes get confused as to which one is being referenced. So in this particular case, it's the court referencing the dates as to when they were filed. But this is a good habit to get into for anyone who's filing anything. If you're filing a motion or an opposition and you're referencing some other document that was entered or filed, you're going to want to do the same thing as the court is doing here. You're going to want to mention the specific date that those documents being referenced to were filed. Next paragraph, the court goes into a summary of the facts. In this case, it's just that we share one minor child. And the court goes over the temporary custody situation as well as the visitation schedule. In the next paragraph, the court goes over a summary as to what I went over in my motion. This is pretty typical, followed by another paragraph covering briefly what my ex mentioned in her opposition, and one more paragraph covering what I mentioned in my reply. Again, this is typically the pattern that I would see throughout my case. He would go over a summary of the facts, he would go over what I filed, what my ex filed, and how I replied, and then he would cite the law, which is what he does here in the next paragraph. This is the definition of contempt, as well as a little bit of case law, and he goes into the basis for denying the motion. In this case, this basis is, in my opinion, just a pretext. He didn't want to hear this. He's probably very busy, doesn't want to hold hearings unless he absolutely has to. In this case, he's looking at a violation of a court order that deprived a father of 2 hours of time, and he isn't really thinking about, yeah, well, she was told not to do it again, she did it again, she was given an opportunity to just flex a little bit of time. All that stuff, he's just going to sweep under the rug and use this pretext, which was that there was no recording of what happened at the case management conference. You don't really need a recording because you have an interim order. And in that interim order, it says how the visitation schedule is supposed to work. My ex has an attorney. Her attorney could tell her very clearly, you have to follow this order. So she can't even really claim that, oh, I didn't know, I'm representing myself, I have no clue what's going on. She has an order. She's violated that order. She was given multiple opportunities, and she even had the opportunity to just give me an extra hour on the pickup time or the drop-off, whatever you want to call it. There is just plenty there for the court to have her held in contempt of court, but the court doesn't want to do that, and the court is just going to go ahead and use a pretext. In this case, there's no recording, so we don't know if she's lying. Well, that's great. I'm not required to prove that she is lying so much as she's required to prove why she doesn't have to follow the court's order. So really, if something isn't in writing in that court's order, the onus is on the person who's trying to give an excuse as to why they're violating the order. The onus isn't on the other person to show, hey, what they're saying isn't true. Because if that was how it worked, they could just say, hey, yeah, Your Honor, I called him last Wednesday at 3:30 and verbally we discussed violating the order. No, let's not say violating, let's say diverging from the order. So now, what's the other person supposed to do? How is he supposed to prove, hey, what she's saying isn't true? You're not supposed to record phone calls without, some kind of permission or authorization, or without letting the other party know they're being recorded. So that person's not going to have any proof. And it's just, in my opinion, a bogus excuse, but I do know why this happens, and I explain why it happens in 2 different videos. The first one that I want the viewers to watch is the video Meta Rulings. The court will make a decision not based on how the facts and the law indicate the decision should be made, but sometimes just based on whether or not the court wants to deal with it, whether or not there's a point to it in the court's eyes, whether or not the court is concerned how the parties will react to an order granting or denying. The video Meta Rulings goes into a whole slew of explanations as to how sometimes the court will enter an order not based on facts and law, but on other things outside of the boundaries of the facts and the law. The other video that I like to recommend in this case is Best Interest of the Parents. And actually, now that I mentioned that, I'm going to go ahead and take that back. It is a good video to watch, but I don't think it's actually as applicable as Meta Rulings. So yeah, take a look at the video Best Interest of the Parents if you'd like to, but I'm going to go ahead and retract that. I think the video that I really want to reference here that I think would help the viewers is Meta Rulings. So I'm going to go ahead and scroll down. Certificate of service indicating that the judge mailed this order to myself and my ex's attorney. And that's going to be it for the order. The next document is the notice of entry of order. Scrolling up here. The notice of entry of order is a video, or it's a document that I have an entire video dedicated to. There's a whole lot behind this notice of entry of order, and it has to do with the timeline for filing an appeal. Definitely watch the video notice of entry of order because that really does matter, at least in Nevada. Anyone who's in another state, it might be similarly treated in your state, so definitely take a look at it anyway, even if it's not in, if you're not in Nevada, and you can go ahead and see if your state actually applies the same principles to the filing of the notice of entry of order. A lot of this stuff comes from the Rules of Federal Procedure. I think it's called the FRCP, Federal Rules of Civil Procedure. A lot of states model their civil rules of procedure after the federal rules, and so I wouldn't be surprised if Nevada got this from one of the federal rules, and if that's the case, there's probably a whole slew of other states out there who are copying that same rule. This just lets me know that an order was entered. It's kind of superfluous because the judge indicated in his certificate of service in his order that it was mailed to me. But like I mentioned, this isn't so much to do something that the judge has already done as it is to trigger the timeline for filing an appeal. And again, those details are in the video notice of entry of order. Certificate of mailing, just like the judge, my ex's attorney includes a certificate of mailing, and just like the judge, it indicates that the document was mailed to me on a specific date to a specific address. Going into the aftermath, the district judge has disposed of my motion for order to show cause. He did so by denying that motion. Going into the financials, my ex and I did not file the order. My ex did file that notice of entry of order, however, that is a free filing, so neither myself nor my ex incurred any costs, so that's going to put us both at $0 in costs. I didn't have an attorney, so I incurred $0 in attorney fees. My ex had an attorney to review the judge's order. She probably charged her, I'm going to say 15 minutes, and the reason why it's so low is it's a short order. It's an order denying, so it really doesn't have any implications for my ex. She doesn't have to do anything. It's precisely the opposite. She doesn't have to do anything. I guess it's the same thing. And the notice of entry of order, she did prepare and file, but those filings are so generic. Oftentimes, the attorney doesn't even do anything on it. It's just a paralegal. The attorney just signs on the line after a very, brief review of the document. I'm not separating out paralegal hours from attorney hours, so I'm going to sort of put the amount that my ex's attorney probably charged for at 15 minutes, so that comes to a total of 30 minutes. At the hourly rate of $250, that's going to put my ex's attorney fees at $125. As with all my previous videos, if you have any questions, definitely post something down in the comments below, and I will see you guys next time.